Hello, everybody. Welcome
Hello.
to our webinar today. We're going to take a couple of minutes. We have a lot of folks registered, so for about 2 minutes, we'll be letting folks in, getting settled, and then we will get into the topic of the day. Feel free to introduce yourself in the chat. That's always such a nice way to know who's in the room, so you can see who of your peers are in the room. We have an incredibly broad geography representation of types of nonprofits here today, which is great. So it is wonderful to be able to see who's here and where you're joining from. So again, if you're just landing in the room now, we're taking a minute to let folks in. We have so much interest in this topic in this webinar, but I will get started in about 1 minute. And we are recording today, and I'm going to start captions. I know that that's something folks requested would be helpful. If there's anything else that you need, don't hesitate to use the chat to let us know if there's anything we can do that helps you participate and be part of the dialogue today. I think we're probably reaching close to our capacity for the day, or at least the folks we're expecting. So I'll just say it again, welcome. Thank you so much for being here at this important conversation today. As you can see on the slide, and as you know, we're talking about property tax exemptions for nonprofits. This is something that the Maine Association of Nonprofits and increasingly the Cultural Alliance of Maine have been tracking as an issue that is getting a lot of attention and dialogue, and there's a lot of need to understand the landscape from a legal perspective of what it means to be a property tax exempt nonprofit. So I'll just share a little bit about some of the context issues happening this year specifically that made it clear to MAMP and to CAM that we really want to create a learning opportunity through this discussion today. So one of the first things that's come up recently is the notion of a pilot program proposal. A pilot, as I'm sure you all know, is a payment in lieu of taxes pilot. And that's often something that is intended to have nonprofits that own, a certain threshold of property value, asking them to contribute in some capacity that's not a tax, but sort of functions as a tax. So we're seeing that, specifically in Portland, but it's certainly something that's come up in many different communities. Also in Portland, but increasingly something that we're, slowly starting to hear rumblings about in other parts of the state. Earlier this year, I'm sure many of you saw a wave of denials and revocations of longstanding property tax exemptions started coming up in the city of Portland. And it affected a pretty wide array of types of nonprofits and types of missions. And that prompted some questions and some attempts at legislative solutions around really looking at some of the state statute that determines, what is benevolent and charitable, which is something that tax assessors will often look to. There's many other aspects of that issue, and we'll be learning a bit about that today. There's also a couple of bills that were defeated this session, specifically LD 438. And I don't have my note in front of me, LD 438 and 1795, two slightly different angles, but both intended to really create new pathways for municipalities to, issue taxes or things that are, basically equivalent of taxes on nonprofits, and kind of clear the pathway for that. Those were defeated thanks to a wide array of testimonies and advocates, and certainly with MAMP's excellent leadership, as always. And the last piece here is that as we speak throughout the course of the past year and into throughout this year, there's a legislative task force dedicated to real estate property tax relief and really looking at not just nonprofit property tax exemptions. There's a whole wide array of types of exemptions, types of dynamics and rules and regulations and established practices and statutes around property tax. And all of this is really coming in the backdrop of this is a very difficult municipal budget era. So let's, certainly that's one of the most important things that we all understand inherently. Even when our municipalities and the folks that run them are incredibly grateful for nonprofits and very supportive, they are still always looking for ways to navigate this kind of affordability crisis, if you will, and how businesses and residents and all are finding ways to pay for increasingly expensive municipal services. So kind of a very complex situation that's become very acute and is affecting, I'm sure, many of you in this room. Molly or Brenda, those are our folks from MAMP who are here on the call. Is there anything else you want to add to this intro here?
Great job, and so great to see so many people here.
Awesome. Brenda is, I'm sure many of you know Mary Alice. Brenda is an interim advocacy lead for MAMP, continuing Mary Alice's incredible work. So without further ado, I will introduce two attorneys who we're so grateful were able to join us today. And so we're not getting into those issues I just mentioned in detail, but what we are trying to do here is just kind of establish a ground understanding for the field about what is the current status of property tax exemption for nonprofits. And so we have Kate Hambley from Drummond and Drummond, who's an attorney with experience in land use, ADB appeals, real estate litigation. And we also have Ben Pollock from Drummond and Drummond, who's an attorney focusing on real estate and related litigation as well. So I will turn it over to them to get into the hefty topic of the day. Welcome, Kate and Ben.
Thank you so much, Molly. I'm going to sort of start out with just a couple more thoughts on framing the purpose of this presentation today, and then kick it over to Ben to cover the sort of basics of the statutory exemption. And then I'll take the metaphorical mic again to talk a little bit about some strategy and some risk mitigation, and also the process for potentially seeking or challenging property tax exemption for a nonprofit. So as Molly said, this is an increasing enforcement area, or maybe enforcement isn't the right term, but there's increasing pressure on municipalities to potentially challenge these exemptions due to statewide budget issues, largely driven by cost of housing and how that trickles down into municipalities' general assistance obligations. But I think also there is a general trend in the case law towards tightening these exemptions if you look broadly from, say, the 1960s to today. And so I think municipalities see more potential to pick up yardage if they do see a challenge through. And I think it's also important to bear that tendency in mind if you're just assuming, or for your budgeting purposes, just assuming that, well, I'm a nonprofit, of course we will qualify. So it's, forewarned is forearmed. And so it's just good to understand the contours of this exemption. Over to you, Ben.
Thanks, Kate. Here we've got our intro slides. Great introduction, Molly. Thank you. I think to start, it's important to really, kind of square what we're talking about here today. And that is essentially just the statute 36 MRS 652, which provides for exemptions for local property taxes for specific types of organizations. This is a separate issue than kind of the 501c federal tax exemptions and sales and use tax exemptions, kind of on the federal and state level there, but specifically for municipal taxes for types of organizations. Now, the statute lays out a bunch of sort of specific categories, but there's two kind of, I'll call them catch most categories at the beginning of the statute, which sets out the exemption for benevolent and charitable organizations and those that are literary and scientific. The benevolent and charitable, the language is that the real estate and personal property owned and occupied or used solely for their own purposes by incorporated benevolent and charitable institutions are exempt from taxation. And part B of the statute is the same thing, except using literary and scientific instead of benevolent and charitable. But those two aren't the only, types of organizations. There are specifically named types of organizations as well in the statute. Those are veterans associations, 652E, general other kind of 501c6 entities. These are chambers of commerce, trade councils, labor unions, and associations of labor unions fall into this category. Churches, other religious organizations is 652G, and then fraternal organizations, but not college fraternities. Think more of like the lodge or other sort of fraternal organizations like that under 652H. For going back to benevolent and charitable for a second, the legislature has recently, I believe it was 2021, set some specific language in there which designates and makes clear that, qualifying nursing homes, mental health facilities, child care institutions, organizations, and other residential care facilities are considered benevolent and charitable for the purposes of the statute and the exemption. We'll start with, there's these catch most categories at the beginning. And so where a term is as sort of vague as benevolent and charitable is, most of and a good amount of the law is going to come from cases, court decisions, and all of the sort of, we'll call these like the boundaries on benevolent and charitable here. Everything on this slide comes from the language of Francis Small Heritage Trust versus the town of Leamington, which was a 2014 decision, which really laid out the bounds of benevolent and charitable. I should say too that case makes clear that benevolent and charitable are synonymous. So it's not worth trying to distinguish that. There's language specifically in there that says, in that case, that says that courts have interpreted them as synonymous phrases. And so the purpose of the organization to fall under the exemption has to be purely benevolent and charitable. There's no concealed profit motive, and the organization can't sort of exist just as a way to avoid your taxes. I said purely for the first one. We'll get into this in more detail, but there are certain avenues, and this is number 4 here on the slide, for revenue production that the court considers like incidental to the dominant or primary charitable purpose. That was, I'll get there in a sec, but basically it's like if it's a small portion of your overall revenue, there is a way to maintain the exemption without jeopardizing it by making some money. So this all comes from the statute. I think it's also important to point out for number 2 here on the slide that the legislature has incorporated this under most of the subsections as well, specifically for, directors, trustees, officers, and employees. For those individuals, if they hold those positions in an organization claiming the exemption, they can't receive directly or indirectly any pecuniary profit from the operation of that organization, except as reasonable compensation for services in effecting its purpose, or as a proper beneficiary of its strictly benevolent or charitable purposes. So just ultimately, no way to conceal your profits if you're truly a for-profit company under the guise of this exception. So that Francis Small case that I talked about kind of sets out a kind of overarching theory for the benevolent and charitable purpose. And I don't think it's fair to say this is the only way to be benevolent and charitable. I think that would be wrong. But one path towards benevolence and charitability is sort of filling the role of the local government for the local government. That case talks about this as a like quid pro quo theory, in that the organization is doing something that the government should or could be doing, and the organization is rewarded with the property tax exemption. If the charitable activity is sort of in line with the government's or the state's public policy goals and objectives, it's more likely to be considered a benevolent and charitable activity. Specifically in that Francis Small case, that was a land trust that they determined to be, qualifying under the exemption, and they reasoned that it could qualify under the exemption because it was essentially acting as a state park. So filling the government's goal of conservation and providing a state park like that put it squarely in the benevolent and charitable category.
And could I add a note there, Ben, that I thought was interesting from the land
Yeah.
trust case? Is the court discussed a much earlier case from the 80s, maybe, that held that a large game preserve that was not open to members of the public was not benevolent and charitable, basically because it was it was closed to the public. It wasn't acting like a park. And the court noted that if that case were decided today, they might reach a different outcome precisely because the government now is so much more involved in species preservation and ecological balancing. We have a lot more environmental regulation now, and that type of function is much more squarely a government function. So really, that factor really does influence how the court looks at the function of your organization.
Thanks. And then the second kind of catch most category are these literary and scientific organizations. On the left side of this slide, the established qualifiers, these are the, long-standing, well-established types of organizations here. So that's, colleges and universities like Kobe College, private prep schools. Hebron Academy is named because that's specifically, there was a court case with Hebron Academy. University of Maine, and other academies and similar educational institutions. This Hebron case was, the Hebron case has kind of a narrow, excuse me. I'm going to compare the Hebron case here to the one on the right side, Hurricane Island, which came to different results while both kind of entities were dealing in education. Hebron, they found the primary purpose of the Academy's education is the engagement of students in the academic pursuit of literary or scientific knowledge through the provision of an accredited course of high school education. And so they found that to be acceptable as a literary and scientific organization, while in Hurricane Island, they found that organization not to be a literary and scientific organization. And I'd say the difference there is, in what the court found, is that while the Hurricane Island Foundation kind of made, in their charter and articles of incorporation, made reference to, we want to excite people about doing science and being leaders in the next wave of scientific discovery. The court found that really their purpose was to provide education for character development, leadership skills, and self-discovery. And so education generally does not qualify you as a literary and scientific organization. And I think that case really highlights how, because it's an exemption, you have to fit narrowly into the exemption rather than there being a presumption that this applies if you're a nonprofit.
And I'll add one more note there too that I thought was interesting is I think another way to explain the distinction between these two educational organizations is that in the legislative history of the exemption, because this goes back all the way to the 19th century, there was a phase in the late 19th century where the legislature kept saying, well, the academic dorms are in. Oh, the academic dorms are out. Well, the academic dorms are in. Oh, the academic dorms are out. And the court took this to mean, okay, well, the legislature has always thought that private schools and colleges count, but they're just going to look a lot more closely at something that seems more hippy dippy. And, I mean, I love Hurricane Island, but I think they're looking at it as like, well, the monocled legislators of the 19th century wouldn't have known that such a thing exists and didn't intend for it to be exempt, so we're not doing it. And I think that might be what's happening behind the scenes.
And then I should note too, this last bullet on the left side here, if you are an educational institution or any sort of nonprofit, the housing for your staff is not exempt. That is specifically set out in the statute itself. So overall, the courts have established a three-part ownership and use test for whether this exemption applies to your nonprofit. The first is what we've talked about so far, whether you're a qualifying entity that's under the specifically articulated organizations in the statute or under those two catch most provisions of the scientific and literary and benevolent and charitable. The next is that the nonprofit must own the land, and I'm going to defer to Kate to talk a little bit more about this. We don't really see exactly why you couldn't be leasing the land, why specifically you need to own it. And then finally, this requirement that your use of the land is solely for your own purposes and for those kind of charitable or scientific and literary purposes. There are exceptions to this rule as well. And I'm going to hand it over to Kate now to highlight number 2. And then our next slide is kind of on these risks of use that may exist under the third stage of this test. Okay, you're muted.
Classic. Okay. I kind of went down a rabbit hole on this topic of leasing. So I was like, well, this isn't fair. Why should a nonprofit have to own the property to qualify for the exemption if they're using it for their own purposes, just like another nonprofit? As far as I'm aware, there's no case affirmatively saying that property leased by a nonprofit and used solely for its own purposes would qualify. But based on a plain reading of the statute, I would think it would qualify. The Hurricane Island case was going to raise that issue. The Hurricane Island Foundation leased the portion of the island that was its property, and that was one of the bases for the town to deny the exemption. But because the court found it wasn't a literary and scientific institution in the first place, it didn't reach the issue. So it's sort of a live issue that's out there. I don't know if it matters that much unless under your lease you are paying your own property taxes or you're about to negotiate a lease and you think that by your landlord claiming the exemption you might get a better lease rate. That's where maybe where the rubber hits the road on that issue. But more to the point is this third prong for qualifying under use test, which is that the property has to be used solely for the nonprofit organization or the benevolent and charitable organization's own purposes. Here's where it gets a little hinky because most nonprofits don't use their property 100% of the time or use 100% of their property. And wouldn't it be nice if you could generate some additional income from that property, or perhaps just in the course of your programming, you have revenue generating activities? So as been alluded to earlier, there are some ways to get some revenue from your property without jeopardizing your exemption. But it's important to remember that except in the case that been flagged of staff housing for literary and scientific institutions, most court cases have held that this is a binary decision. It's not like, oh, if I'm going to let 10% of this parcel be used for glamping on the weekend, so I want the parcel to be 90% exempt. No, it's either you use it solely for your own purposes with certain carve-outs, and then you get your exemption, or you don't. So we're going to talk more about how to manage that issue down in the strategy section, but I just want to flag that for now. It's kind of zero sum. So things that could potentially jeopardize the exemption are making too much money and or using it in ways that aren't really aligned with your mission. And those uses can fall under, there are sort of two ways it could defeat your exemption. It could make the court say, well, you are not dominantly a benevolent and charitable institution, or your operations aren't dominantly literary and scientific. So it could change how the court views you as an organization. But it could also, even if you've cleared that hurdle, say, well, no, this isn't part of their core mission. They're just running a parking lot that you have to pay for parking. You still then have to show that you're using your property solely for your own purposes. So it's kind of two potential pitfalls. So things that could jeopardize it are leasing a portion of your property to an unrelated for-profit entity. This might not be obvious, but granting easements or other sort of property rights to private parties that then make less than the whole parcel yours could jeopardize it. Allowing private events, other third parties to use the property. But the court has held that there's sort of two categories of carve-outs or safe harbors. One is what I would think of as auxiliary or incidental uses. These are uses that are clearly not part of your core mission, but go hand in glove with the core mission. And the classic example, and there was a case on this, is a hospital parking lot. The nonprofit hospital doesn't exist to provide parking to the public. That is not their core mission. But hospitals need parking lots. They wouldn't be that helpful without them. So running a parking lot, even if you're generating revenue from that, is incidental to the primary use, and that was deemed okay. So we've got incidental uses. The other category would be de minimis use, and this is what you would argue if your use is totally unrelated to how you execute your mission. You don't need this use in order to do your mission, but the income you generate is de minimis. It's just not that significant, and it doesn't impact how you use the rest of the property. The Hebron Academy case is a classic de minimis use case. In this case, the Hebron Academy was leasing its athletic fields to private events, travel soccer, that sort of thing. And they were able to show, well, it's a very small portion of our budget. It's only 1% of our budget. It doesn't impact how we run our activities at all. We still get first dibs for all of our sports. And, it's just not a major part of how we do business. And the court said, that's fine. Contrast that with there's this other case, not a Supreme Court case, Superior Court case, where a religious nonprofit housing corporation owned an apartment building, but the first floor was leased to private doctors under just private commercial lease, and then they had a restaurant, same deal. It amounted to 18% of their annual budget, and the court was like, no, that is too much. That is not de minimis. That's a hefty chunk of your annual budget. There's also some older cases that would seem to be much more liberal on this point. A lot of them involve camps from the 60s and 70s. And so in a summer camp situation, you primarily use it in the summer, and they're saying off-season use is fine. It doesn't affect how you use your property. You can lease it off-season. I don't know if those cases would come out the same way if they were tried today, because off season is, 3/4 of the year in Maine. So who knows? I would just say like those cases are out there and maybe be careful in relying on them too much. We do the next slide. Yeah. Okay. Affordable housing has some curious and, not to be too nitpicky, terribly worded provisions in the statute that are super confusing. Full disclosure, I don't have any anecdotal evidence of how this applies, so I am doing my best to interpret what has happened to the statute, and there's no cases on this either. So if anyone has more direct experience with how municipalities and courts are interpreting the affordable housing rules, I would love to hear how that works. But the basic premise is up until the 90s, it was assumed, and there was a case on this, that if you're a nonprofit organization and you meet the requirements of a benevolent and charitable organization, and you own an apartment building or other housing and you are renting it on a subsidized basis, whether it's federal money, whether it's private subsidy, wherever the money's coming from, if it's below market, that is benevolent and charitable and you are tax exempt. In 1993, the legislature passed a amendment basically saying, nope, we're not doing this anymore. Going forward, you don't get your exemption. Then they passed in the same legislative session another amendment saying, we changed our mind. We're just going to do a small carve out that says that you only get a 50% exemption. And that's only for situations where the housing was built or placed in service by a for-profit entity before 1993 and then transferred to a nonprofit entity after 1993. And it's federally subsidized, specifically federally, and it's 9 or more units per lot. In that situation, you're going from 100 to 50. There was also language that they added that seems to me to be duplicative. That's basically just saying if a nonprofit builds it after 1993, you get your exemption. Well, I mean, it's also true that if a nonprofit built it before 1993, it gets an exemption. Or if a for-profit transfers, it didn't seem to make a lot of sense because it doesn't address all combinations of what could happen. But I'm just going to leave this out here as the affordable housing rules. Generally speaking, you go through the same test as anyone else. Are you benevolent and charitable? Is it used for your purposes? But be aware there's some specific statutory caveats. Okay, let's get into sort of some risk mitigation and strategy. The first thing to bear in mind, and we didn't address this in the beginning, is that generally courts have interpreted this statute to only apply to organizations incorporated in Maine. And that's because the statute used to say that explicitly and now it doesn't. And there are a bunch of constitutional reasons why they probably can't do that, but why fight it? It costs $50 to just create a Maine-based subsidiary if you're an out-of-state nonprofit. So you might, if you're an out-of-state nonprofit owning property in Maine, you probably want to create a Maine subsidiary and have that subsidiary own the property. The other sort of major area where you can control your fate here is to clearly articulate your mission, and you would do this in mission statements and your articles of organization, in your bylaws, but you do it in a way that makes it clear that any uses that could be challenged, if there's a legitimate basis for calling them incidental, remember incidental is sort of the hospital parking lot scenario, try to do that. Try to articulate your mission in a way that makes it clear that these incidental revenue generating activities support your mission. I think a good example of this might be if you're an arts organization and you serve alcohol, maybe define your mission not just as promoting artists or supporting the creation of art in Maine, but your mission can also include getting people in the door to see the art, to talk about the art, to forge social relationships over the art. Alcohol helps with all of that. Your core mission is not going to be get alcohol to the people, but alcohol service starts to look a lot more like an incidental use to your core mission if you redefine it that way. In general, a lot of cases rejecting literary and scientific organization status, I I read them and I'm like, why didn't they just go for benevolent and charitable? Literary and scientific is getting smaller and smaller as an exemption, and I think you're going to have more success just characterizing your organization as benevolent and charitable, especially because the government is involved in more and more things. So it's easier to say, we do this thing. Maybe I'll use the example of an arts organization again. We promote art and artists, and that's benevolent and charitable because that this is something the government also does now. We have grants for art. We have local downtown art councils. We have all of these things. We are supplementing a governmental use. We've kind of discussed the question of own versus lease. If you own your property, you're not going to have to worry about this issue of does the statute authorize an exemption for property that's merely leased to a nonprofit. But if you're stuck with a lease, give us a call. Happy to talk that through. The area that I think is most exciting is the idea of slicing and dicing up your property. And I think it's possible to get a little too cute with this strategy, but it is a viable strategy. So as I discussed, these exemptions are kind of zero sum. It's possible that I'm just not aware of what the practices in most towns are, but most towns will say you need to use your property, meaning the whole thing, solely for your own use. Well, if you're leasing 10% of your parcel to some private entity, one way to fix that is to redefine what your property is. If it's possible under zoning, you can split that property and have the smaller parcel now be owned by an affiliate that is nonprofit, for-profit, whatever, but you're leasing out this subset. And so the rest of the parcel, the 90%, stays solely for your own purposes because you've just redefined the denominator essentially of what you're looking at when you're looking for that 100%. And you could do this in terms of creating more lots if you own a lot of land, and huge caveat, it has to work under zoning. You could even do this through condoization. So if you think about the Marcotte case where I mentioned there was a nonprofit housing organization that owned an apartment building with mostly subsidized housing, but some they had a private lease to some doctors on the first floor and to a restaurant on the first floor. They could have condoized that building and made condo unit A all of the housing on top and condo unit B the doctor's offices on the bottom, because then condo unit A is used 100% for subsidized housing, which is a recognized benevolent and charitable use. Again, I think it's possible to get overly cute with this. Like, what if you're a summer camp and you want to rent it to whoever the heck you want, you corporate retreats for the rest of the year, and you do a timeshare. So now my nonprofit only owns the timeshare to the summer months. And so we are 100% using our timeshare for a nonprofit use, but the other half of the year belongs to a private entity. Who knows? If someone wants to make some case law, give us a call. Or maybe a court would say, no, that's not what this is for. That's too cute. The last sort of strategy is to do a payment in lieu of taxes. There are we've been using this word pilot in sort of two different ways. One is a municipality might enact a pilot program, which is a blanket deal saying in our town, you must voluntarily pay 40% of your property taxes, and we're going to name and shame you if you don't. But you can also do a sort of bespoke, customized pilot between you and your municipality. And it could be beneficial, even though you are paying more than $0, and that is a hit. If it helps take the enforcement energy away or reach some sort of agreement or stasis for the next 5 or 10 years, that could be a lot more beneficial to you, in terms of saving on legal fees, generating goodwill with the municipality. It's a totally viable strategy. And I will just add that goodwill for the municipality thing, it does matter. I mean, there are ways that a municipality could illegitimately sort of retaliate against a nonprofit for successfully seeking exempt status. But there are also legitimate ways that it can maybe not retaliate, maybe that's too strong, but legitimate ways that it can express its displeasure with a nonprofit's non-payment of taxes. For instance, the big one that comes to mind is, and this is especially common for educational institutions, is if you need a contract zone because you own a big campus and you're under a special agreement with the municipality about how that works. That is a purely discretionary decision that the municipality does not have to give you. And so if you go and seek a contract zone or an amendment to a contract zone and you have a lot of property and it's exempt, it's going to come up in the contract zone. So especially if you're anticipating a big expansion or something like that, a pilot is something you might want to consider throwing into the mix. Okay, I'm going to shift gears to talk a little bit about process for how you become exempt and how you would challenge a denial. I just want to note, in case we didn't note at the beginning, that we have some hypotheticals at the end that we could scrap. But anyway, there's going to be plenty of time for questions at the end. I'm just saying as questions come into the chat. So, first, as part of your regular property tax deal, the assessor will assess all the property, and part of that is you have to submit your exemption paperwork demonstrating why you think you're exempt by April 1st. And depending on your municipality, or really for most municipalities, the bare minimum requirements for seeking an exemption are going to look very light duty. It's essentially, ask for the exemption, describe what type of organization you think you are, benevolent and charitable, literary and scientific, 501c6, what have you. And then attach articles of incorporation, bylaws, maybe a mission statement. It's all town specific, but that's pretty much what you'll see in most towns. 90% of the time, it pays to be more thorough than the town form would suggest. There's absolutely no reason why you can't also submit a narrative explaining what your organization does, what its core purposes are, what its operations look like, whether you have any private income, why that private income is incidental or de minimis. You can get ahead of the ball here, and a stitch in time saves nine. If the assessor approves it, great, you've got your exemption. That exemption will remain in place. You don't need to refile every year until the assessor gives you a call and says, you're not exempt this year. Like, we're going to need to see some more evidence. So once you get it, you're good until it's revoked. If it's denied and the assessor says, sorry, I think you are exempt, then you have two options. One is to just go right to court with a declaratory judgment. And that option is available as an exit ramp anywhere along the other approach I'm going to describe. The court, in most municipal processes, you're not allowed to do that, but for whatever reason, courts have approved going straight to court for tax disputes. And that might be appropriate if this is a long-running issue, you've had a lot of back and forth with the town, you don't trust town leadership, or at least don't trust them to really engage on this issue, and they're just dug in, that might be the most efficient thing. The alternative process is to see through a series of administrative appeals, which, if successful, great, you've got your exemption. If unsuccessful, you still have the option to go to court. That administrative process looks like, once you get your adverse decision from the assessor saying you're not exempt, you have 185 days from the commitment date, which is not the same as the date you found out you got this bad decision. It's a date that is the same across the whole town. It's called the commitment date, and you can just call your town and ask when it is. You have 185 days from the commitment date to file for an abatement, which is like a request to have fewer taxes. And it's that same process for anyone in that boat. What happens next would be an informal hearing with the tax assessor, or possibly tax assessor and other municipal officials. It varies by town, and it's set in the town code who would be there. This is often very informal. It's not like a court. It's not even Judge Judy. It's sometimes just a Zoom meeting with the assessor. Within 60 days, and in that meeting, you are welcome to bring as much evidence to support your position as you want, as many arguments as you want. Within 60 days of that meeting, the assessor has to give you a decision, yay or nay, on your abatement. If the assessor forgets to do that, it's deemed denied, so it defaults to denial. If you are denied, again, at that process, then you have another 60 days to appeal to the Board of Assessment Review for your town. If your town doesn't have one, then it would go to the county commissioners. And that's a little bit more formal. It's a little bit more like a hearing. It's de novo, so meaning you have another opportunity to get in more evidence, really build up the record, put in as much as you can. Probably get a lawyer if you're at that phase, would make sense. Um, at this point, there are two paths, one for residential properties and one for non-residential properties or properties over 1 million. So 1 million isn't what it used to be. A lot of you probably own at least $1 million in property. So, and non-residential typically would mean anything where people don't eat, sleep, and drink. So there's a little ambiguity in what that means when you're a nonprofit, but let's assume that most people would fall into this category. So you get your denial from the local Board of Assessment Review or local county commissioners, and then you appeal to the state Board of Tax Review. And that is statewide board. It's pretty formal. I believe that's also de novo, meaning you have another opportunity to submit more evidence. And hopefully that goes your way, but if it doesn't, then you can appeal that through Rule 80C to court. And then you're in big boy court, and that is typically not de novo. You are locked into whatever evidence you submitted below, and then you are just making your arguments, again, probably through a lawyer. If you're not successful there, then it goes to Maine's law court. So if you find yourself in an appeal, we've kind of covered all of this, but hire a lawyer, know your deadlines, know the rules of procedure. Most things are won by the rules, not the substance, or a lot of things are. Build a strong record, and then also consider a pilot in parallel. It's always an option to just settle something through a mutual agreement and not have to deal with this. So if you can pay less in taxes than it would cost to hire the lawyer, I highly recommend you do that. I think I'm going to say one more thing about enforcement risk, which I think helps you know how hard you have to worry about this. If you are in a small town with a very small tax base and you are a big nonprofit or you own a lot of property, you are a high user of municipal services, you're a target. So if your property has a lot of police calls or a lot of emergency calls or whatever it is, if it is viewed as a burden on the tax base, it is your potential enforcement target. So big fish in a small pond, you might want to devote some resources to thinking this stuff through. Okay, so just a couple things on what to watch. We've kind of covered this, but I'm just going to mention pilot programs again are these sort of universal pilot name and shame programs, and those might be coming down the pike. We don't really know. There is a state task force convened to look at a bunch of real estate exemptions. They've done an interim report. Nothing is final, but they are looking at what is the future of this exemption. Also bear in mind that in Maine, if the town is giving you guff about how hard it is on them to have these exemptions and not be able to tax you, something to just keep in the back of your head for when you're making informal arguments is the state does reimburse towns for the taxes lost through this exemption by at least 50%, and there are arguments the municipality could make for getting more. So lest you feel too sorry for the towns for losing out on this tax money, just bear that in mind. All right. I think the last page I had sort of prepared some hypos, but I think it might be more useful to go into real life hypotheticals, non-hypotheticals, and field some questions if folks want to do that.
Thank you so much, Kate. I think that was great. Would you mind going back to the hypotheticals just to keep it up? I mean, I'm going to read you
Yeah,
some
sure.
questions that have come in, but then just in case any folks have questions about those specific issues, then maybe we can prompt you to kind of elaborate on a couple of things.
Sure.
So again, thank you so much. That was fantastic. So I've been gathering questions that have been coming up in the chat, so I'll just kind of share a few of them. One of the things that came in ahead of time with registration, if a nonprofit who has a very clear, like never challenged, benevolent purpose, all of that, they're not.
Oh, did anyone else lose Molly? Okay.
Yes, I think we lost Molly for a moment there. We do have a few while she comes
Did I
back. This
freeze?
is Molly from MAMP. Yes, Molly,
She's
are you
back.
back?
Freeze, I froze, right?
Yes,
Yes.
but you're back.
Okay.
Great. Welcome.
Heard that. It should open a kind of like very, maybe even a up at a museum. What should they do to kind of think through that decision?
So I think you were asking, because it was a little choppy, if you have a sort of flagship entity where no one's ever even thought to challenge their exemption, what should that entity be aware of?
Sorry, if they're opening a revenue generating like thrift shop or gift shop or something, what should
Yes.
they think through?
I think the big thing, and I haven't mentioned this, is don't ignore the possibility that your revenue generating activity might make more money than the exemption saves you. So I think that people can easily fall into this thought process of we must pursue tax avoidance at all costs. No, if your real estate property taxes are 20,000 a year, but you could make 60,000 a year if you rent to weddings every single weekend, you should do that. It's okay to lose your property tax exemption. That might be a smart move. The other thing is if that's not the case and you're not going to make enough money to make it worth it to lose the exemption, you want to keep it. Um, it needs to be the revenue you generate needs to be a small portion of your budget. There are no hard and fast rules, but I can tell you in the case of the 18%, it did not work out for them. 1%, okay. Other factors matter. So if you were at 8% of your budget, but the use is something we would commonly associate with a museum, or of course they do that, and it's even kind of artsy, like that's gonna matter. It's not purely a numbers game. Um, I think again, a strategy of making sure you articulate your mission and your purpose in a way that could potentially bring that private revenue generating use closer to what you do is going to be really helpful. So if your mission didn't include public outreach or public engagement or anything like that, then it should, because that starts to make this revenue generator potentially not just be de minimis, but potentially fall more into incidental, related or auxiliary to your primary mission.
That's really helpful. Thank you. There was also a question, just to go back to something you just shared. Could you elaborate on that piece about the state reimbursing an exemption to the municipality? Is that if like a new state level statute comes into play and then they
No,
have to sort of, yeah.
that's old. That is in the state constitution. And it doesn't really affect anything that a nonprofit does, because the nonprofit would never see the money from this. But it's an argument to bear in mind. And that's that it's possible municipalities don't even realize this. So they're leaving money on the table. But the state constitution says that when a statewide statute creates a tax exemption from municipal property taxes, the municipality can ask the state to reimburse it for lost taxes up to 50%. There's a separate constitutional provision in our state constitution that says that when the state creates a mandate, it has to fund that mandate up to 90%. It's called the unfunded mandates rule. So I think the municipalities are entitled to at least 50% of lost taxes. And there's an argument out there that they could say, well, we need more because this isn't just a tax exemption. This is an unfunded mandate.
Okay.
Yeah.
Got it. So it sounds complicated, but not necessarily something that an individual nonprofit's exemption would suddenly trigger any kind of.
No. Yeah,
Yeah.
it's more
Okay.
just something to bear in mind if they're doing
Gotcha.
a sob story. If even
Gotcha.
tiny little town is like, we can't afford that, blah blah blah.
Gotcha. So another question that came up, this notion about prorate property taxes, a formula that prorates them. Like again, let's say use a random example where you have a great big property and you let to a couple of welders your back parking lot, and you do something related to craft or whatever. You're getting rent from somebody for something. If you could just speak a little bit, because I know there's this binary aspect you mentioned, but then there's this kind of carve out potential too. Speak a little bit to how that prorated property tax level could play out.
Sure, yeah. So, in theory, I think a strict reading of the statute would say that it's zero sum. So, if you have a portion of your property that's you're using as like a maker space, to use your example, and you're renting it out to private individuals to do their welding or their pottery or what have you, and that's starting to generate a sizable portion of your income, and it's not really related to what you primarily do, you could lose your exemption for the whole property because the court would say you're not solely using the property for your nonprofit purpose. So rather than like to avoid that, to avoid the situation where because you're using 10% of your property to generate revenue and losing the exemption for the whole thing, you can either pull back on that revenue generating use, or you can try to split the property so that 100% of the 10% is exempt and 100% of the 90%, or I'm sorry, 100% of the small makerspace, the 10%, is not exempt, that's taxed, and 100% of the 90% that you use for your daily nonprofit operations remains exempt. So, but I also, I'm going to kick it back to the audience with a question, which is that this binary concept of no prorating, unless in specific circumstances like staff housing, I'm not sure that that's what's happening in reality. I know that's what's happening in the cases and in the statute, but it wouldn't surprise me if a bunch of people in the chat said, my assessor says, we're 90% exempt because only 10% of it is revenue generated. That wouldn't surprise me at all. And I'm not even saying that that's invalid. It's just the couple superior court cases that have looked at this have looked at it as binary.
Well, if anybody wants to speak to that, please by all means chime in. But I'll also flag a couple of questions about pilot in the chat. One of them is about, the best way to set it up. Another one out of the precedent that might, and I also want to third consideration. Let's say you're like, for a month a year when we're totally empty, we actually want to let people use it to do XYZ. And let's say, well, maybe I could set up a 1/12 because it's 1 month, a 1/12 pilot with my town. Like maybe that's something I could explore. So just thinking about that pilot concept.
That's a great
considering-
idea.
Yeah.
Yeah, Molly, that's a great idea. That is sort of another way to get to proration because it doesn't really change anything about the legal status of it, but it would really reduce a town's incentive to go to the mat on that issue. And I think I'm seeing some comments about pilot that I actually completely agree with. I'm seeing from Julia Gray, I worry about doing a pilot setting a non-legal precedent and making the exemption a bit fuzzy. I think that's a valid concern. I mean, if you do a pilot for a couple years to kind of get the Eye of Sauron off your nonprofit, and then in 5 years from now, you're like, we can't really afford this anymore, we want out. I think it might, on a human level, not a legal level, but just on a personality level, be harder to backtrack. So I think that is a valid concern. But there are examples in the cases of towns doing exactly that. We did a pilot for a bit. Sorry, we can't afford it now. Now we're going to go to court over whether we're exempt.
Well, I know we are right at 2 o'clock and there are so many more questions. And I'll feel free to continue to email questions to myself, to MAMP. This is something that we want to continue to develop learning and understanding about. Thank you so much to Ben and Kate. This was incredibly helpful. I feel like you really got into such detail that is very hard for those of us outside of the law profession to really wrap our heads around. Incredibly helpful. And thank you to everyone who attended today. We've recorded, we've done captions, we have a transcript, and we'll be following up. If we can find answers to some of the questions that didn't get answered today, we can at least sort of start to compile those together as things that we are as a field, really still trying to wrap our heads around. So please keep the dialogue up around this very live, very, very complex issue. And again, thank you all so much for being here. And thank you to the amazing people at MAMP for everything you do to lead the way on learning opportunities and advocacy around issues like this and so many others.
Thank you for having us, and thanks everyone for attending.
Yeah, thank you everyone. And the questions are great, and I want to keep answering them. So if anyone just wants to email me, I might have time to just shoot you an email. Feel free.
Kate, it sounds like it's okay if we send your emails in a follow-up email.
Yeah, they're
about
actually
this.
in the slides too.
Perfect. Perfect. Yeah, and we'll send the slides out.
All right. Thank you, everyone.
Thanks all. Bye-bye.